Now, First Choice responded to this outright attack on them with a federal lawsuit. 2 days before the deadline to produce documents, First Choice filed suit in federal district court seeking to prevent the Attorney General from enforcing his document demands. Shortly after that, the Attorney General responded with his own suit in state court. There, he accused First Choice of violating state law by failing to comply with his subpoena. Between the two suits, much litigation followed. So First Choice sues in federal court, claiming the subpoena infringes on their rights. And the Attorney General sues in state court because, well, First Choice didn't comply with the subpoena. Who has the better case? A federal law, 14 U.S.C. Section 1983, authorizes suits against any person who, under color of state law, deprives another of his federal constitutional rights. First Choice filed a complaint under that statute, arguing, among other things, that the Attorney General's demand for information about its donors violated its First Amendment rights. While I agree that First Choice does have a case under 1983, it's not a First Amendment case. Why? Because the first 5 words of the First Amendment are, Congress shall make no law. A.G. Plotkin was not acting under the authority of a law passed by Congress, so his actions cannot violate the First Amendment. What they do is violate the Fourth Amendment because it is an unreasonable search and seizure of documents. As the Fourth Amendment says, the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated. To me, this is not only a more straightforward argument, but on a better constitutional footing. Specifically, First Choice observed that the First Amendment prohibits the government from discouraging people from associating with others in pursuit of many political, social, economic, educational, religious, and cultural ends. And First Choice alleged the Attorney General's subpoena had just that impermissible effect. For its donors, the group presented anonymity is of paramount importance, and its inability to guarantee that anonymity in the face of the Attorney General's demands injure the group by discouraging donors from associating with it. That's a pretty good argument, but not for the First Amendment. That argument shows a violation of Article 1, Section 18 of the New Jersey Constitution, which reads, the people have the right freely to assemble together. Now, First Choice did more than just file that lawsuit. In addition to its complaint, First Choice filed a motion seeking a preliminary injunction prohibiting the Attorney General from enforcing his subpoena. In support of its motion, First Choice tendered 2 declarations. In one, anonymous donors represented that if they had known information about their donation might be disclosed through an official hostile to pro-life organizations, each of them would have been less likely to donate to First Choice. The donors added that they submitted their declarations anonymously because they believed they might face retribution otherwise, given the Attorney General's record of hostility toward pro-life groups. In the second declaration, the group's executive director similarly represented that the Attorney General's request threatened to weaken First Choice's ability to recruit new donors, as prospective partners would be hesitant to risk the revelation of their personal information through government investigation. So at least some donors would have been less likely to donate if they knew their information would be passed out of the AG's office, based on his record of hostility to pro-life organizations. Again, a good argument, but for a violation of the New Jersey Constitution, not the First Amendment to the Constitution of the United States.